Hello everybody, welcome to my channel. Today we are going to talk about appeals and compensations under SARFAESI Act. And appeals to DRT is one of the often tested MCQs in the law officer examinations. I can be 100% sure that this question will come. Either how much days a borrower, within how many days a borrower has to appeal to the DRAT. That can be a question. Or the pre-deposit rule, which we will see later, can also be a question. So these two are very important. So listen to this appeals and compensation chapter till the end so that you can actually answer questions, confirmed questions. Remember, even answering one question correctly significantly improves your chances of getting to the final merit list. So what we'll cover the sections 18 and 19 of the SARFAESI Act, that is how the appeals to DRAT is done. Remember, after a section 13.2 notice, you have to wait for a section 13.4 enforcement by the bank. And if those enforcement action is against the SARFAESI Act, you can actually file a case in DRT within 45 days of the particular action. And if the DRT's order is not uh, as per your legal arguments, or if you feel the DRT has failed, erred in law, then you can actually appeal to the DRAT within 30 days of the receipt of this order. So this is an often asked question. So do practice this. And the next part is, what is the pre-deposit rule when you appeal to DRAT? And the caveat, we are going to see the procedure and caveat and the right to compensation in case if the DRT finds that the banks have actually violated SARFAESI procedures, then they can restore the possession of the property back to the borrower and also order compensation and costs. So the remedy hierarchy we have to see from the creditor taking action, that is that under 13.3a you can write to the creditor. If the creditor is actually not responding, or if it is against, if you feel the creditor's response is against law, then you can approach DRT within 45 days, and then you can approach the DRAT within 30 days. And in case if the DRAT is order you want to go for further appeal, you can actually approach the High Court. Now we'll come to the appeal to the appellate tribunal. Now remember, this appeal happens after you receive an unfavorable order from the DRT. And any person, again, just like the DRT filing of case process, the same applies to DRAT, that any person, not only the borrower, any person can, aggrieved by the order of the DRT, can approach the DRAT, and the appeal must be from within 30 days. Remember this. Remember this. This is very important. If a secured creditor initiates a 13.4 action, then the it's not an appeal. The first course of courts or the original jurisdiction lies with DRT, and that takes place within 45 days. You have to appeal within 45 days. And next, if the order of DRT is not in your favor, you have to appeal within 30 days. So you have to remember this day. That's why I'm saying repeatedly the 30-day period for appeal to the appellate tribunal, that is DRAT. Now, after the 30-day period, this is the most often tested principle. This can be seen as a confirmed question, the pre-deposit rule. When you are appealing to DRAT, you have to, as a general rule, deposit 50% of the debt owed by the borrower to the secured creditor. Now, in case if the 50% is not deposited by the borrower, then the DRAT has the discretion until and unless it reduces it into writing and why it has reduced the pre-deposit amount. The maximum limit of reduction can be up to 25%. So you have to at least deposit 25% of the debt owed by the borrower to the secured creditor. Now, 50% is the mandatory limit, and the DRAT, for reasons to be recorded in writing or reduced in writing, can reduce the deposit amount up to 25%, nothing below 25%. So, these two questions, that is, the limitation period of appealing to DRAT from DRT, that is 30 days, is often asked. Next is the pre-deposit rule, that is the 50% is the mandatory rule, and it can be reduced up to 25 percent. These are the most asked questions. Now remember, after DRAT, the borrower or any person has a chance to go for further appeal to the high courts or supreme courts under the extraordinary writ jurisdiction. So there's no timeline, but the courts do expect it to be done in a reasonable time. The reason why there is no timeline is because SARFAESI Act is itself a strict procedural act. Now, if a DRT and the DRAT is actually uh, rejecting the appeals, then usually by the time the banks would have sold the property would have changed hands, registration would have happened, and it would be extraordinarily difficult for the borrower to approach the high courts or supreme courts under writ jurisdiction and then restore the possession back to them, until and unless they can prove grave injustice. Other than that, I don't see the writ jurisdiction or the appellate the writ jurisdiction of the courts helping the borrowers in this case. And in fact, Supreme Courts have time and again sidelined. I can see a pro bank tilt in Supreme Court, which is obviously expected because these are public money. So this is very important. You have to understand how the appeal process happens. And remember, even after the 2016 amendment, the redemption of mortgage, that is the ability of the mortgager to redeem the property, the mortgage property, that is lost the moment sale notice is published. So the borrower is in a very weak position here until and unless the bank has done a major mistake or which violated the justice principles. It is extremely difficult for the borrower to take to restore the possession of the property without fulfilling their debt to the secured creditors satisfaction. Now, what is the procedure? How the DRAT decides? The DRAT decides in accordance with the rules of the RDB Act, and of course, like I said, further challenge lies to the High Court. There is no limitation. However, uh, even if the limitation period is done, you have to the particular borrower has to file a case in a swift manner. Otherwise, by the time there is a delay, the property would have been sold and changed hands. So DRAT decides based on the principles in RDB Act and the right to lodge a caveat. Now, as a law officer, this is very important. The moment you take a SARFAESI action, it is prudent to lodge a caveat applications in DRTs and DRATs. So, if a bank expects the borrower to uh, challenge their actual SARFAESI action, then they can file caveat. So the right to file caveat is another often tested principles. I don't see much of MCQ coming in, but this section, the filing of caveat is one thing that you would come across regularly as a legal officer in bank, especially in retail banks. Now, this is another important section that you must understand, that if the DRT feels that the secured creditor has violated the procedures in SARFAESI Act, then they can actually award compensation and also put on the costs of the litigation to the secured creditor. Now, of course, at the end of the day, this compensation and cost, these are very rarely given to borrower because most of the time it is about invalidating the SARFAESI Act. And once they invalidate the SARFAESI Act, the bank is going to restart the SARFAESI procedure and maybe correct the procedural errors. So this is, I have not come across many instances where the right to compensation and costs are awarded to the borrower, but there is a provision because look, the banks are not infallible institutions. There are managers who, most of the managers are very good and honest, but there are managers who can actually involve in other uh, illegal activities, especially with regard to the disposing of the property. So in that case, this is a very important section, but this is very rarely used. But still, it's on paper that you must understand that the right to compensation and costs is available for the borrower if the DRT or DRAT or for the High Court determines that the secured creditor has violated the principles in SARFAESI Act. So the compensation is for like any aggrieved person or also borrower, and so that is how it is very important. So right to compensation. So this is also available under the SARFAESI Act. It's not just the restoration of possession of property or rolling back of SARFAESI Act. So right to compensation also is available. Now remember, uh, the 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 DRT or DRT courts can only do restore the property or give compensations for wrongful possession, etc. But they can never ever stop the bank from restarting the SARFAESI proceedings or approaching DRT or a civil court or any other appropriate legal remedy under IBC codes. So you must remember that. So the remedy hierarchy, like it said, when the secured creditor enforces action and gives a 60-day possession, a 60-day notice, demand notice, the borrower has the right of representation. And if the right of representation is not satisfied, if the borrower is not satisfied with the right of representation, then he can file an application when section 13 for enforcement measures are taken, either a symbolic possession or a physical possession is being attempted. Then 45 days from that action, the borrower can approach the DRT. And if the DRT's order is unsatisfactory, they can approach the DRAT. That is 30 days. That is 30 days. And even if DRAT's orders is not uh, to to the satisfaction of the borrower, they can also always approach High Court and Supreme Court under writ jurisdiction. There is no timeline, but like I said, since SARFAESI happens very fast, it is usually that the borrower, an aggrieved borrower, would have to move to the High Court and Supreme Court swiftly because his property would have already reached a sale or auction level. And like I said, after 2016 amendment, once the sale notice is published, your right to redeem the mortgage property is eventually lost. Now, a quick recap: Section 18 relates to appeal to DRT. That should be 30 within 30 days of the DRT's order, and pre-deposit of 50%, and the DRT can reduce it up to 25%. And there is a right to lodge a caveat, and compensation and cost can be given. And ordinarily, 50, the test yourself question talks about the 50% rule, which is the most, it is one of the superstar questions in MCQs for law officer examinations. Now, if you have any doubt or if you're not understanding the concept, do type it in the comment. I will read all the comments and try and clear it to the best of my ability so that you will not be having any doubts on the examination day. Do share this video with any of your friends or anybody whom you know or is preparing for this exams, and do like and share and comment on this video, which would help for a better reach, and do subscribe to my channel. Thank you.